Okay, good afternoon, everybody, and welcome to today's webinar entitled The Changing Face of the City Centre and hosted by Walker Morris. The purpose of today's webinar is to look at the continuing evolution of the city centre and to consider that in its legal context. Now, your speakers today are Martin McKeag, myself. I'm a partner in the real estate litigation team at Walker Morris. You also have Josh Kitson, who's a director in our planning team. And the final speaker is David Mander, who's also a director in the real estate litigation team. Now, the city centre is, of course, always evolving and changing, but I think it's fair to say the last 15 months or so have brought about a series of changes and trends that might ordinarily have taken place over a decade or even longer. It seems to me clear that the city centre as a hub of retail activity is likely to be severely diminished going forward. You only have to walk around the city centre to see lots of shops are closed, lots of units are empty. City centres in some respects have a slightly drab, dilapidated appearance to them. And I think that applies even in what might be regarded as more affluent parts of the country. So the question is, what's going to replace that retail use? I think at the moment that's a difficult question to answer. It's a pretty fluid situation and it may be a number of years before things settle down, but it does seem to me there's likely to be a move towards more residential and leisure schemes. But if city centres are to thrive, there's going to be a need for greater diversification and therefore change. And as a litigator, I'm acutely aware that change and disruption often lead to as well. And therefore in this webinar, Josh is going to consider some planning changes that assist in facilitating redevelopment, and David and myself will look at some development issues and how developers and property owners might manage those issues. So we'll talk for around 40 minutes with questions to follow, and we'll wrap up around 1 o'clock. So if you do have questions, please feed those through as the webinar is ongoing. So first of all, I'm going to hand over to Josh, who's going to talk about the new permitted development rights that have been brought in by the government over the course of the past 12 months in order to seek to rejuvenate the high street. So over to you, Josh.
Thanks, Martin. Good afternoon to everyone. Thank you for joining us today. As Martin mentioned, I'm going to talk to you briefly this afternoon about the role the planning system is playing in seeking to rejuvenate the high street and the city centre. As Martin mentioned, the impact of COVID has been stark and it has exacerbated existing challenges faced by high streets and city centres. I think it's probably helpful to set a bit of context to this before going into the 4 different permitted development rights and change of use points I've put on the first slide there. In terms of the context, what I would mention firstly is that the overall retail vacancy rate has increased to approximately 14.1% in the first quarter of 2021. Secondly, internet sales as a proportion of all retailing rose from about 15% in 2015 to around 20% just before the start of the pandemic, and this figure peaked at around 33% during April 2020. In the first quarter of this year, London City office vacancy level stood at more than 8%, and the restrictions imposed during lockdown obviously had a significant impact on footfall in city centres and high streets. And when those restrictions were eased, it was the commuter and seaside towns that recovered the quickest. Major cities, which rely more on commuter traffic, saw slower recoveries in footfall. Further evidence of this, the issues that are faced on the high street and city centres, is that since 2012, approximately 725 department stores have closed down across Great Britain, and around 275 of those remain vacant now. This climate does still provide opportunities for others though, and there are a couple of recent examples of old Debenhams buildings which are now being sought to be put to new uses. The first example is at the University of Gloucester, which has purchased an old Debenhams building which they intend to use for lecture halls and research labs. And secondly, in Leeds city centre, the old Debenhams building is proposed for use as a student residential halls together with other mixed uses. This application is proceeding at the moment. Now, in terms of the reforms that are on the slide there, I'm going to run through these briefly. The first is flexible use classes, which is the Class E use class that was brought in last year. I'll just mention that briefly, as I'm sure most of you will be well aware of that by now. The second point I'll talk about is the new permitted development right to move from Class E to residential. This comes into force in August this year. The third point is the permitted development right to extend upwards. This came into force last year. There are a few intricacies with that which are worth dwelling on, I think, and there are some opportunities there. And finally, the fourth point there, the permitted development right that was brought in last year to allow for existing vacant buildings to be demolished and rebuilt as a residential dwelling. So if we can go, David, to the next slide, where I've just set out what is contained within Class E. Now, Class E includes shops, restaurants, cafes, offices, gyms, nurseries and health centres. It doesn't include drinking establishments or hot food takeaways, so these have now been placed into the sui generis use class. And if you want to move to or from those uses, you now need planning permission. The purpose behind this change in introducing Class E is to provide greater flexibility. It also provides greater clarity to those seeking to operate more mixed-use establishments. I think one point to look out for in particular in practice is for any planning conditions on existing permissions that predate the Class E introduction on the 1st of September 2020, and to see if any of those conditions restrict any change from the existing use, because that may prevent you benefiting from the Class E flexibility. It's important just to carefully review those as you look at them. So if we can go to the next slide, David. Sorry, I do sound a bit like Chris Whitty doing this. So if we can talk about, so the next point to talk about is the Class E to C3 permitted development right that comes into force on the 1st of August 2021. Now this replaces the previous office to residential permitted development right that was first introduced in May 2013. This became permanent in April 2016. Between 2015 and 2020, about 73,000 new homes have been built under permitted development rights. This is roughly 10% of the new homes delivered across that period. So it's not a massive amount, but it is a reasonable proportion of new homes that are being delivered in this country. The government published research in July 2020, which was led by University College London. This was critical of the quality of housing built under permitted development rights, particularly when compared with those authorised by a detailed planning permission. The sorts of issues this report looked at included the number of units which met the nationally described space standards, the amount of natural light which permitted development units generally received, and the amount of amenity space which residents had access to. This report has informed the government's approach to the new Class E to residential permitted development right. There are a few criteria which are flagged on the slide, which I think are worth being particularly aware of. Firstly, there is a size limit of 1,500 square metres. This is a tightening of the previous position. Previously, under the office to residential PD right, there wasn't a similar floor space restriction. The second criteria to be aware of is that buildings must be vacant for a continuous period of 3 months before it is eligible to be converted. Thirdly, prior approval must be sought for matters relating to transport, contamination and noise. I've also mentioned on the slide the need to comply with nationally described space standards. Now, by way of an example, to see the impact of this change, this means that for a one-bed dwelling with a shower room, the floor area needs to be 37 square metres. Now, when we look at other schemes, I'm sure we've all seen them before, where much tighter room sizes are provided on some schemes. It's also worth touching on natural light. The University College London research was quite critical of how some PD schemes that they reviewed had approached this issue. They found that just under 0.5% of PD dwellings that they looked at had been built without windows. Now, this is obviously not something we want to be encouraging. The legislation now requires adequate natural light in all habitable rooms, and this is a matter for consideration at prior approval. This again is a tightening of the restrictions imposed, and it gives more control to local planning authorities. It's also important to remember that any external alterations to the building that seek to rely on this permitted development right are likely to need a separate planning permission. The government view this permitted development right as a means of revitalising the high street. They want to see new homes on or near the high street, as Martin mentioned in the introduction. It will be interesting to see how much take-up there is of this opportunity, because as we've just gone through, there are some restrictions there which make it less attractive than perhaps it once was. Now, if we now move on to upward extensions, I've put on the slide there the 3 different extensions that are available. First one on the left-hand side, from the 1st of August, the government introduced a new right to allow existing purpose-built detached blocks of flats of 3 stories or more to extend upwards to create new self-contained homes. The right allows up to 2 additional stories to be constructed, up to a maximum height of 30 metres. To qualify, the block of flats must have been built after the 1st of July 1948, but before the 5th of March 2018. So this rules out more new built developments. a developer is required to seek prior approval of various details from the LPA before they can proceed. The details that need to be addressed include heritage issues, highways impacts, contamination, and flood risk. As with the Class E to residential permitted development right that we've just discussed a few moments ago, this right also requires consideration of whether adequate natural light is provided in all habitable rooms. Now, the second two boxes on that slide refer to new permitted development rights that came into force at the end of August last year. Now, they allow for additional stories to be added to freestanding blocks and on buildings in a terrace that are houses or in a commercial use. The rule allows for additional stories to be added to existing freestanding buildings in use as shops, financial and professional services, restaurants and cafes, offices, and some other uses. This allows up to 2 additional stories of new homes to be constructed on top of freestanding detached buildings of 3 stories or more. This is up to a maximum height of 30 metres. The rules on how many stories you can add to a detached or terraced house vary depending on how many stories the current property is made up of. I won't go into this now as it's not the most interesting topic, but it is something that needs checking in detail before schemes are progressed. And the other eligibility requirement that is important to be aware of is that there is a maximum height restriction of 18 metres. In addition, the building must have been constructed post the 1st of July 1948 and before the 5th of March 2018. Prior approval is also required of various details for both the permitted development right shown in the middle and right box on that slide. This again takes account of points like highways, natural light, and any noise issues from nearby commercial premises. It's important to remember that the principle of development isn't intended to be up for debate at this point. It is those finer grained points of detail. Now, if we can move on to the next slide, which again is just looking at the opportunity provided by upward extensions. It's an interesting quote from the government, I think, that's on the slide there. They seem to believe, or they believe that 800 new homes per year will be created through building upwards on purpose-built flats, which is the box on the left on the previous slide, and 7,800 per year will be built on all other buildings. Now, when you consider that 73,000 homes have been provided via PD in total in the last 5 years, this does seem ambitious. I've not seen any figures yet of how many homes have been delivered to date since these PD rights were introduced in August last year. However, it'll be interesting to see what the take-up is like. One point that may be challenging for all concerned, and is something to give some more thought to, I think that it's something the government is giving some more thought to, is the time it will take for local planning authorities to deal with these applications. The fee that is payable for a prior approval is small. However, the prior approval process for upward extensions will be time consuming. If there is significant take-up of this permitted development right, it could well put pressure on local authorities because they're having to review matters such as rights to light, highways, contamination, drainage, and so on. And there, in terms of capacity, I think most local authorities would not, they wouldn't say they were awash with capacity to take on additional work at the moment. So the government are going to have to think about how they're going to try and provide more capacity for local authorities. And the final permitted development right, which I just mentioned briefly, relates to the demolition of vacant buildings, which are allowed to be rebuilt as residential properties. This right again came into force on 31st of August last year. Essentially, it applies to either a purpose-built detached block of flats, a former office building, or those used for research and development, or any combination of those uses. To benefit from this right, there are 3 key criteria that you need to be aware of, and these are set out on the slide. The building must have been built before 1st of January 1990. It must be vacant, entirely vacant, for at least 6 months prior to the application for prior approval, and it needs to have fallen within the office use or the other uses mentioned on the slide on the 12th of March 2020. Now, there is a limit placed on the size of the properties that can benefit from this use. So the footprint of the building that's to be demolished and to be rebuilt cannot be greater than 1,000 square meters. There are also height restrictions to be aware of as well. The maximum height can only be 18 meters. However, a new building may only be up to 7 meters higher than the old one. Now, the purpose of this limit of 7 meters is to accommodate 2 additional stories. So this ties in with the previous PD rights I was mentioning a few minutes ago. Now, this right also allows for the installation of a basement or cellar in the new building, whether or not there was one in the old building. This also will provide additional floor space. Now, local authorities are provided with some controls through the prior approval process. They'll be able to consider highways impacts, the design of the new building, impacts of noise on residents, and again, issues relating to natural light. This again sounds like a detailed review of the scheme. And again, I would query whether the local planning authorities are going to have the capacity to turn these around quickly. The idea behind these permitted development rights is to allow homes to be provided quickly and to circumvent, but to avoid going through a detailed planning application and the time associated with it. Now, if local planning authorities don't have the capacity to provide that service, then it's going to be difficult to do that. But it is important as well when dealing with these applications to keep in mind that the principle of development shouldn't be up for debate. Now, these are quite, I wouldn't say radical, but obviously novel and new permitted development rights in terms of extending upwards and the ability to demolish and rebuild. So I suspect there are going to be some debates over the principle of development between developers and the LPA, and that's something that's going to need to be carefully managed. Now, the purpose, I think, behind these 4 new rights that the government has introduced is to try and provide more flexibility in city centres and high streets. They also form part of the government's aim to provide more homes in this area. But also, on the other side of the coin, there are tighter restrictions imposed as well, relating to matters of size, natural light, and space standards, which may make some of these permitted development rights actually less attractive than the ones they've replaced. It's going to be interesting to see what sort of demand there are for these sorts of homes in a post-COVID world, where the demand for housing with gardens has obviously increased dramatically over the last few months. So these 4 rights are ones that are going to be important to monitor, and also to see what benefits can be extracted from them. So on that note, I think I'll pass back to Martin, who I think is going to talk about restricted covenants.
Thanks, Josh. I think you spoke earlier in your segment about Debenhams, and which I think is a really good example of what we're talking about today. I have a client who is looking to convert a Debenhams into residential apartments, and I think it's that sort of scenario that I'm concerned with, in terms of where you've got an existing building, it's used, say, for office use or retail use. That use has become redundant or no longer economic or valuable to you as a developer or property owner, and you want to use it for housing, for example, but there's a covenant on title prohibiting residential use. So what are your options? And in the first slide and the second slide as well, we sort of map out a few of the obvious options that are available to you. And first and foremost, as a developer, you look at insurance. You look to insure against the risk, so that if a beneficiary did bring a claim against you in relation to the covenant, you've got the benefit of an insurance policy. I think insurance is probably the most commonly used way of managing that risk, but it's not some panacea that's going to provide a perfect solution to all issues. For example, it's not typically available pre-planning. It's not going to cover you for development profit. It's only going to cover you for diminution in value. It's not going to give you that development profit back. Often it won't also cover you for delay in your development costs. So you'll be left essentially picking up the tab often for those delay costs whilst the claim is sorted out. It's not always the case that the insurer and the insured's objectives or commercial aspirations are aligned. The insurer will understandably want to settle the claim on the most economic basis, and you as the developer or property owner will simply want to get on with the development, and therefore they will be saying to the insurer, well, we need to just pay up and get on with this. But it is often used in the context of restricted covenants, the type of work that myself and David do in the insurance sector. These are probably the most common types of claims that we would see, along with absence of easement policies. So it is an option. It's probably the most common option used in the context of developments and restricted covenants. The second option, which you can consider, is express release through negotiation or mediation. The important point to appreciate is that if you seek to negotiate with beneficiaries, you are basically going to bar yourself out from obtaining insurance. Obviously, insurers price the risk, and if beneficiaries on notice of the claim or have intimated the claim, then understandably, that risk becomes far more significant. I think you do require leverage if you're going to seek to negotiate, otherwise it really is an open checkbook. You don't necessarily need a winning argument, as we often say to clients, but you do need a position to negotiate from an argument sufficiently strong that the beneficiaries think, well, they might lose. And we'll come on to talk about Section 84 applications in the next slide and how those might be used as a platform to negotiate a release from. It's also important to check the beneficiary's title, their site operation. Do you have any potential counterclaims? And I think another limitation on seeking a release is a practical issue. If you're dealing with a covenant, say from the 19th century, how do you actually identify who the beneficiaries are? If you've got multiple beneficiaries, then it's difficult to negotiate with, say, 20, 30 beneficiaries. And of course, there's no point in doing a deal with 29. You leave one out of the equation because that one can obviously stymie your development. So next slide, please, David. The third option, which I put in slightly tongue-in-cheek really, is building breach, which you just get on with the development, ignore the covenant. It's not advisable. Perhaps, I don't know, 20, 30 years ago, people might have viewed this as a serious option, but the courts take a pretty dim view these days of any developer who would just simply get on with its development and seek to ignore the covenant. The standard remedy for breach of restrictive covenant is, as I've said in the slide, an injunction plus a potentially hefty cost bill. You can also find yourself on the end of an order requiring you to demolish the property. That's what happened in the Millgate Developments case. From the beneficiary's perspective, delay on their part in seeking to enforce the covenant can be a bar to an injunction, but it won't of itself then preclude them from a damages claim. The court is in certain circumstances prepared to convert the property owner's right from a property right into a monetary claim. That monetary claim can be very substantial, can equate to up to 45% of the development profit. So I think unless you are an incredibly courageous developer, I wouldn't recommend building in breach. The courts expect you to consult. The fourth occasion of the tribunal to modify or discharge the covenant. So if you have a covenant, for example, that said you can't use the property for residential, you would seek to modify it so you could use it for a particular residential scheme. Those applications are being granted far more frequently now than they were 5 or 10 years ago. It's more streamlined, it's a swifter procedure. I'm not saying that it's not going to take weeks or even months to resolve, but typically you'll be looking at something around 12 to 15 months. Importantly, you do need to have a specific scheme. You can't just say, I want to use this building for residential. If we move on to the next slide there, then what I wanted to give was 2 examples of where applications to the upper tribunal have been successful. The first example I'm going to give is an example where the applicant relied on ground AA, which essentially is the most commonly used ground, and it's where the covenant impedes some reasonable use of the land, and the covenants do not secure practical benefits of substantial value or advantage, and that money will be adequate compensation for loss or disadvantage suffered. Now, the example here is, I think, a really good one for the city centre. Although this pub wasn't located in the city centre, I think a lot of the issues and principles that come out of it are relevant to issues, I think, that are going to arise over the next few decades in the city centre. You'll see the pub had been closed down due to economic inactivity, been sold off to developers. They wanted to convert it to a spa, but there was a covenant saying you can't use the building for any shop or trade. And if we look at the next slide, we can see there that the application was allowed. And essentially it was allowed because the covenant no longer secured practical benefits to any of the beneficiaries. The pub wasn't trading economically, it was closed up, it wasn't the community hub that the objectors suggested that it was. It was an area in need of regeneration. There was a real need for a spa, a supermarket convenience store. There were also a considerable number of other public houses in the vicinity. So that essentially was a covenant which no longer served any useful purpose. And really the discretion that the upper tribunal has is designed to deal with those situations where you've got historic covenants which at their time served a particular purpose, served a particular use, but over time have become redundant, because the nature and character of the area has moved on. So you can see, can't you, that that sort of example is probably going to crop up in the city centre, where you've got covenants against certain activities, but time has moved on and those covenants no longer actually secure any practical purpose for the beneficiaries. And just to give it balance, I'll then move on to the next slide, which is an example of where the application didn't succeed. This again was under ground A and also ground AA. Ground A is obsolescence, which is almost impossible to prove. But this concerned a proposal by the University of Chester to develop a boathouse for the rowing team, and this was in a picturesque area, and it was in breach, or it would have been in breach of a covenant that no letting of boats of any trade or business shall be carried out. And as we can see from the next slide, that application was refused. And essentially, that application was refused because the covenants themselves have been remarkably successful in preserving the character and amenity of the area. As it says at the bottom of the slide, it preserved the very unusual character of this small corner of Chester. And therefore, then the tribunal, in weighing up the balance of convenience, came to the fairly firm view that the degree of damage that would be caused to the amenity and enjoyment of the beneficiaries' property was so significant that in view of the tribunal, then the application wasn't made out. And again, that sort of principle may well resonate in the city centre if you have got a part of the city centre that is quite green, quite verdant in its characteristics, and there are covenants which seek to preserve that, and there is an application to modify those covenants, for example, to put a large residential scheme or a mixed-use leisure scheme in breach of that covenant, then you can see that dependent upon who objects and the location of the beneficiary's land, you can see that those sorts of arguments might run into the same issues that were had in relation to the Sandy Lane development here. So I suppose the message is that I think Section 84 in these examples is probably something which can be used, generally speaking, in city centres, but there will be occasions where it may not be successful. The key ultimately is evidence, and when we come on to the next slide, evidence is key, as I say there. And I think if you as a developer, property owner, are dealing with a property that's got a covenant, you're thinking, well, will Section 84 assist me here? Some key questions to ask yourself are, well, what does the covenant say? For example, does the covenant prohibit your proposed use, but would it allow significant intrusive development in any event? And that's the test in Fairclough Homes. So when you're looking at potential other schemes that might be allowed and which would have significant impact on the amenity, you need to bear in mind that those schemes do need to be realistic. You can't just put forward an alternative comparator which has no realistic basis, whether in planning or in economic terms, because the tribunal will simply just disregard that comparable. Also ask yourself who's got the benefit of the covenant. What sort of people are they? Are they rich? Are they poor? Are they sophisticated? Will they have the ability to fund an application to the tribunal? These are not inexpensive applications. How many of them are there? As I said earlier, in this segment, it's more complex to deal with multiple beneficiaries. Look at the nature of the benefited land, if it's capable of being ascertained. What would be the impact on the use of the land? Look at the geographical distance as well that the benefited land has to the development land. Another important point to bear in mind is that there's no limit to what can constitute a practical benefit of substantial value advantage. But the important point, the absolutely critical point to bear in mind, is that they do have to relate to the use and amenity of the benefited land. They can't be, for example, it cannot constitute the ability to extract a ransom. So that will not constitute a practical benefit within the meaning of Section 84. And then in terms of the practicalities of making an application to the upper tribunal, discharge or modification, the golden rule here is never ask for more than what you need. A well-drafted modification should always be sufficient, drafted by reference to the planning consent that you've got. I can't think of any real circumstances where you should need a full discharge. Always go for modification, far easier to make out. Equally, is there anything relevant which might be of relevance to exercise at the tribunal? For example, in the city centre, there will be a lot of leasehold covenants. You might find, therefore, then that you've got the council, who is the beneficiary, and can money be adequate compensation for a council? The council has other duties and responsibilities of a civic nature, and the council might argue that actually it cannot be compensated in monetary terms for the prejudice suffered, and in those circumstances then the application would of itself fail. And then practicalities, as I said earlier, generally applications a lot quicker than it used to be, still going to probably take 12 to 15 months from start to finish. You do need to factor that into your development programme. Costs don't always follow the event, but if the application fails, then the applicant will almost certainly have to pay the objector's costs. But it doesn't work the other way around. It's not quite the same as county court or high court litigation. So even if the application is successful, by no means guaranteed at all that the objectors will need to pay the applicant's costs. In terms of compensation, compensation can be ordered under ground AA, but it is typically modest. Otherwise, it must follow, mustn't it, that essentially the covenants do secure practical benefits of substantial value or advantage, and therefore in those circumstances the application will fail. So I think in terms of summing up this section, I think section 84, as a developer, if you come across covenants and they prohibit what you do, an important point to note is that applications can be made in both in relation to freehold and leasehold land, where the lease is more than 40 years and 25 years have expired. So it can operate in a leasehold context, and it can operate in relation to anything which is restrictive. So it can operate in the context of restrictions on use, restrictions on assignment, restrictions on alterations. So it can be a really useful tool if you are faced with a covenant that prohibits your use, and it can, as I say, give you a good platform to negotiate from in the face of beneficiaries asserting their claims. So I'll then hand over to David, who's going to talk to you about easements and principally I think about rights to light in the context of developments. So over to you, David.
Yeah, thanks, Martin. As Martin says, I'm going to, as it says on the slide, I'm going to discuss three things really. Easements, and then I'm just going to touch on very briefly rights of way really. I'm going to go into a bit more detail about rights to light and also discuss section 203 of the Housing and Planning Act as well. Firstly, in terms of easement, unlike what Martin has just discussed, there's no right to modify or discharge easements in the same way, or certainly not as yet, in relation to that. So the first step is really to understand what the meaning and scope of any easements may be, because it's only once you've done that that you can then understand whether any potential development is going to one, interfere with those easements and obviously enable a third party to complain about the proposed works. Now, in terms of any interference that there may be, the first point to note is that not every interference is going to be actionable. In order to be actionable, there has to be a substantial interference. Obviously, it's going to be very fact specific, but the test was laid down really in the B&Q case. And the question there is that can the right of way, as I say in that instance, be substantially and practically exercised as conveniently as before? If the answer to that is yes, then obviously there is no substantial interference, and obviously arguably not actionable. If the answer to that is no, then obviously the opposite would apply. Now, another question I often get asked in relation to easements is whether they can argue, or a party can argue they've been abandoned, and often it comes across because their historic easements, such as a right of way, hasn't been used for a long period of time, and the short answer is probably not, because not only the courts are very reluctant to infer easements have been abandoned, it's actually quite difficult to establish unless there is some very firm action taken by the beneficiary of that. And I've referred there to the case of Ben and Hardeen because it's a sort of classic example where the exercise of right of way basically it wasn't used for 175 years, and throughout that whole period there was actually an alternative route used, and still the court refused to accept accept that the right-of-way had been abandoned. Another question I'm asked in terms of right-of-way is about providing an alternative route. Again, it will depend. Firstly, is there a right actually allowed in either the grant of the right-of-way or subsequently that enables the serving owner to amend or alter the route of the right-of-way? If not, then it can't unilaterally be done. But what I would say, and I think the important takeaway in terms of alternative routes, is that it may well assist in any claim in terms of a remedy, because for the interference of an easement generally, the general remedy is injunction and or damages. And if there is an alternative route, it may, in certain circumstances, assist to persuade a court that actually the appropriate remedy should be damages rather than injunction, which would obviously allow any development to proceed. I'm going to now move on to rights to light. And I appreciate that is an easement as well, but I think it warrants a separate section. Now, in terms of rights to light, the first point is to understand, well, how can they actually be acquired? And I've sort of listed the three ways really there on the slide. Express grant or reservation is really what it says. It's there in a document and it's a deed. And I've got to say, more often than not, when you're dealing with rights of light claim, they're generally speaking either acquired by implication or prescription. So dealing with implication first, there's two ways mainly it comes up, and the first is the rule in Wilden and Burrows, and the second is section 62 of the Law of Property Act 1925. Now, both of these provisions really relate to where you're talking about a transfer of part and where land has been retained by the seller. And I won't dwell too much on this because it can be quite a complex area, but broadly speaking, for the rule in Wilden and Burrows, you're talking about those easements that were continuous and apparent and necessary for the reasonable enjoyment of the land that was granted. And section 62 is essentially a word-saving device where it's a statutory provision that operates to deem that on a transfer of land, unless section 62 has been excluded, all easements, including rights to light, would be conveyed with the land transferred. The third way I mentioned on the first slide in terms of right to light was by way of prescription. And again, there's sort of three subways, if you like, under prescription that the rights to light can be acquired. I mean, the first one is rarely used in its common law prescription, and the reason for that is simply that it requires use as of right since 1189. So really, you're only talking about the most sort of ancient of buildings, as it were, that would be able to rely on that provision. It's really the second and third elements there, being lost modern grants and section 3 of the Prescription Act, that come into play. Lost modern grant, what we're talking about here for prescription is long use over a period of 20 years or more, and that use has to be as of right, and that essentially means without force, secrecy or permission. And the important point to note on lost modern grant is the enjoyment of the light has to be between freehold owners, so it's not a case of lesser interest being able to claim. It is lost modern grant can only be claimed by a freeholder against a freeholder. In terms of section 3 of the Prescription Act, again, similar in that you're talking about 20 years long use, but there it does not need to be as of right. But the issue that more often than not comes up under section 3 is that of whether there's been permission or consent for the use of the right to light, I should say. And I've put there that an oral license will not defeat the right, and the reason for that is there has to be some form of written agreement or written consent in relation to that, and that may well be in documentation in the historic title deeds, and so a review of that would need to be undertaken. So obviously, the important point to note is, the important issue to consider is, well, if there is a right to light or someone is looking to acquire it, or there's potential for somebody to acquire it, well, how do you potentially defeat such a claim? And I'm going to talk about six ways, I suppose, I think most likely to come up and things to consider. The first of those is unity of ownership. And essentially, you're talking about there the dominant and servient land being owned by the same person. And it's the important takeaway there is that occupation of the dominant and servant land is insufficient. It does need ownership in order for that unity of ownership to defeat any claim. The second is abandonment. Again, it's similar to what I discussed under the section on easements. There has to be a fixed intention. So the obvious example in a right to light claim may be the blocking up of a window, and obviously that may assist to say that the right of light has actually been abandoned and there's a fixed intention never to exercise that right in the future. Thirdly, you've got obviously express releases. Similar to, as Martin discussed with restrictive covenants, often the difficulty with getting express releases is getting that release from all of the potential parties that may have a right to light, especially in a city centre setting where you may be surrounded by a number of buildings. That can often prove difficult. And the important thing is to note that it has to be, any release has to be by deed. So it can't be under contract, can't be under, and the important thing there, sorry, in terms of the deed is to ensure that successors in title are bound. And obviously you would then seek to register any release against the relevant titles. The fourth way, if you like, of defeating a claim is actually by way of a physical obstruction. And that's dealt with by Section 4 of the Prescription Act 1832. And I've split it up because, and when I say pre-acquisition in this sense, or pre and post-acquisition in this sense, I'm talking about pre-acquisition of the right to light itself. Because pre-acquisition, then obviously firstly there has to be the physical obstruction, and that has to remain in place for a period of at least 1 year. So it's not the case that you can put up an obstruction, take it back down. It has to be continuous and stay there, and as they remain in place for 1 year in order to defeat any claim. Post-acquisition, again, you've got the physical obstruction, but the difference here is that this has to be go unchallenged by the dominant owner, which is a person that is claiming the right to light for 1 year. And again, if that remains in place, then again, that will assist to defeat any claim for right to light. And the difference between the two, as I say, is really in pre-acquisition stage, you may be talking about, well, an obstruction going up, let's say at year 15, and that remains in place obviously for 1 year. Well, that would prevent the 20 years continuous use from adjoining buildings, and therefore that would assist in terms of defeating a claim. The final way to try and defeat a claim is in relation to light obstruction notices, and this is covered by the 1959 Act mentioned in the slide. And basically these were introduced because they avoid had the need for a physical obstruction, and they're actually notices that can be registered against title, and as I say, they're registered as a local land charge, and therefore are searchable. Now, in terms of actually trying to obtain a light obstruction notice or a LON, you can get either a definitive or a temporary certificate, and they're issued by way of an application by the upper tribunal. And in terms of a temporary certificate, that generally arises if where there is, as I've said, exceptional urgency, and the obvious situation is that you believe that adjoining property may acquire right to light very soon because they're either on the cusp of reaching the 20 years, and therefore you, rather than delaying in obtaining the light obstruction notice and getting that registered, the tribunal would award a temporary certificate, pending obviously that may be made a definitive, but you would get that temporary certificate, that would be lodged and registered in the normal way, and then the obstruction, if you like, would run from the date of registration of that notice. I've said there the LON takes effect until the end of the period in the temporary certificate, so generally speaking that is 6 months, or after the expiry of 1 year. Again, it's linked to the point of how ensuring that the obstruction remains in place for 1 year. And as I said, that is treated as an obstruction under Section 4 of the 1832 Act. Finally, I'm just going to touch on Section 203 of the Housing and Planning Act. And basically, Section 203, very quickly, and I'll read this, it says, a person may carry out building or maintenance work to which this subsection applies, even if it involves interfering with relevant rights or interests. And essentially what Section 203 does is give a power to override certain rights as long as compensation is paid to the dominant owner. Now, I've put there the problem with this is that the power can only be used by local authorities, but there is a way around this problem. What you can do is ask the local authority to actually acquire the land from the developer and obviously sell it back to the developer subject to indemnities in respect to the compensation, and I'll come back to that shortly. But effectively what you're doing is a sale and buyback, which enables Section 203 to then be used. And as I say, that would then look to override certain rights, including rights to light, and also certain easements as well, subject to, as I say, compensation being paid for the other parties or benefiting parties. Section 203 applies to any person and obviously includes any person that derives title from the local authority, so successors in title. The courts have effectively confirmed the sort of sale and buyback option that I mentioned is feasible. And I think one key point in my mind in terms of this is that there's no requirement to give notice or publicity in relation to this, unlike there is under a CPO. So, but the fact there is no notice means that you're not putting those parties that could essentially bring a claim, for example, a breach of the rights to light, on notice. You're not putting them on notice of it, and therefore it reduced the risks of having to deal with injunction claims before the sale proceeds, and obviously Section 203 is implemented. The risk, I think, with Section 203 lies in the compensation point, because obviously the obligation to pay lies with the person that derives title to the land. But if the developer doesn't pay, then that liability is enforceable against the local authority. So hence, for any local authorities that are listening, the importance there is obviously ensuring the indemnities that are in place, and obviously they are worthwhile and enforceable. And even if you use the sale and buyback option that I mentioned, the requirements of Section 203 have to still be complied with, in that there has to be planning permission that's granted. The development's got to be undertaken on land owned by the local authority, as I've just discussed, and the development has to be undertaken for the purpose for which the land was acquired. So as I say, I think just summing up very briefly in terms of my section, whilst Martin obviously dealt with the issue of restrictive covenants, I suppose the point to take away as well from my perspective is that there are other issues that may need to be considered in terms of any development, and it's not, whilst there are potential pitfalls, if you like, or potential hurdles to any development, I think, as I've mentioned with the right to light, there may be potential avenues that allow you to defeat a claim, or at least get ahead of it and create a strategy before your development, so that those risks are managed and potentially reduced completely. But equally, there's this option of Section 203 that if that is certainly, as I say, a feasible option, but if you can get the local authorities on board, that may also assist to deal with some of these other issues that may be a barrier or impediment to any development. And that brings us to sort of the end of our bit, if you like, in terms of our chat and our talking. And now it's time for questions. So please feel free, anyone has any more questions, to put them into the Q&A function. I have got one here for you, Martin, actually. Can an application be made to the upper tribunal to modify lease covenants such as restrictions on assignment and alterations?
Yeah, I mean, I think I covered that point off towards the end of my segment, but yeah, yes, it can. In certain circumstances, it can't be used in the case of a lease that is granted for less than 40 years and has less than 25 years expired. So it can't be used, in a common, sort of shop lease or a shopping centre lease, which typically won't tick those boxes. But yes, assuming that the lease comes in the criteria, then yes, it can be used. It doesn't have to necessarily be about use. It can be about anything which is restrictive, anything essentially which is a covenant which is properly regarded as being restrictive in nature. And I have had cases where we have been the applicant and also where we have been the objector, effectively the landlord, in relation to those cases. So yeah, that is something which can be used and something which is worth bearing in mind, particularly in city centres, as I said as well, particularly in Manchester, for example, lots of leasehold, long leases there. So it's certainly worth bearing in mind.
Okay, Josh, I've got one for you as well. You mentioned about prior approval being needed for natural light into habitable rooms. What test would the LPA apply when determining that issue?
Thanks, David. I think in terms of how that would work, the test in the legislation is whether the amount of natural light is adequate in habitable rooms. So there is an element of an objective test to be applied by the local planning authority when an application for prior approval is submitted. So I think when the details for that go in, it would need to be carefully considered in advance how that was being presented, because I know that the government's taken a lot on board from this University College London report from last year, which is quite critical of the kind of lower quality PD schemes that have happened in the past. And I think there is a bit of a push now to try and raise the quality of the schemes that come forward. And I think you'll also see local planning authorities, you might see them in terms of the test of adequacy taking more of a hard line on this. So I think it's a point that that needs considering at the outset of the design of the scheme to make sure that the scheme can go through the planning system as quickly as possible.
And I suppose just thinking that through in the sense of, although the council, local authority might be looking at natural light in that sense, it's still going to be from a planning perspective. So even though you get planning permission through or consent or whatever it might be, I think one thing that I always, again, that seems to come across me is saying that, well, we've got planning, therefore, someone's complaining about the impacts on their right to light or the natural light. Well, I suppose the point being that planning permission or planning consent or planning rights don't override those private rights.
Yeah, exactly, and that would be a similar point for the upward extensions PD that I mentioned earlier in the talk. That those sorts of rights would bring with them private law considerations that would need properly testing before kind of the scheme got off the ground.
Yeah.
I can see, David, there's a question for you rather than you ask yourself a question. I'll ask it of you. And the question is, do I still need to worry about a claim in relation to rights to light if the buildings around the site have been demolished? I think I've got that right.
I think, well, I suppose if they've been demolished and rebuilt, then there still may be a claim because you can get what's called transferred rights. So effectively that would apply where old building with windows, apertures, etc. that let in natural light, that is demolished. New building is erected and there is a level of coincidence, if you like, between the location of the old apertures and windows, etc. Between the old windows and the new windows that are put in on the new building. So in that respect, there's still something to be worried about. So if, for example, I'm looking outside our offices now, the adjoining building was demolished well, I don't know, 12 months ago and rebuilt, it doesn't follow that just because it's been demolished, that brings an end to that claim, as I say, because of those transferred rights. So that would still need to be considered. And then you potentially get into complex arguments about parasitic losses, which is effectively losses over the whole of the building, not necessarily just the extent of what the old building was, as it were. But that can get, I think that's a topic in itself for another day.
Okay, good. Okay, well, it's coming up to 1 o'clock. So that seems an opportune moment to wrap things up. So I hope you've all enjoyed the webinar, taken something from it. If you do have any other questions or would like to speak to us about anything more particularly, then by all means get in touch. So thanks everybody for joining.